Good day, ladies and gentlemen, and welcome to the Tension in California between migrating employees and protecting trade secrets conference call. My name is Katina, and I'll be your coordinator for today. At this time, all participants are in a listen-only mode. If at any time during the call you require assistance, please key star followed by 0, and the coordinator will be happy to assist you. I would now like to turn the presentation over to your host for today's call, Ms. Beth Parker. Please proceed.
Hello, everybody. Our program today is called The Tension in California Between Migrating Employees and Protecting Trade Secrets. I'm Beth Parker, and with me today are John Lombardo from our Los Angeles office and Jeremy Cameras, also from San Francisco. During the program, please feel free to use the chat feature tool within WebEx to ask questions. We will not answer them as we are speaking, but at the end of the program, if there is time, we will try to answer as many of your questions as possible. Since time constraints may not enable us to get through all of them, please do not hesitate to contact any one of us directly after this call, and our contact information will be on the last slide and on the materials that you receive. The lines have been muted. If, however, you need assistance during the conference, press star, then 0 on your telephone, and a conference coordinator will assist you. The event is also being recorded and may be posted on the Arnold and Porter website, where it will be available to the public. Shortly after the program, we will send a link with the presentation materials to all of the participants in today's program for your convenience. So thank you. Theft of confidential company information by former employees has been and continues to be a major problem. This is particularly so in high-tech companies and other companies where a lot of research is happening, whose major assets are the trade secrets they develop. In fact, a major study found last year that nearly 60% of departing employees admitted that they stole company data when they left. 67% of these took it to secure a new job, and 79% knew they should not have taken it. And they took it in a variety of ways. Some took paper files, some downloaded information to CDs, DVDs, or USB memory sticks. Some sent it as an attachment to an email and then sent it to their personal home email account. And what they took encompassed a large swath of corporate information: customer lists, business information such as strategic plans, research and development, financial information, and employee records. In California, how to handle this is somewhat tricky due to two competing public policy concerns. On the one hand, California values employee mobility. We in this state want employees to work for whomever they want to, and they can even compete with a former employer. So as a result, except in a few very narrow circumstances, non-compete agreements are generally void in California. By contrast, in most other states, non-competes are generally enforceable as long as they are reasonably tailored. This often means that they must have time or geographic or other boundaries, but you can still have non-competes. But what's interesting about the strength of California's public policy against non-compete agreements is that most California state courts will not enforce another state's injunction against an employee who leaves an out-of-state employer, comes to California, and joins a California employer. And that is true even if the former employment contract includes a choice of law provision that says another state's law will govern. So as a result, there has in the past often been a race to a courthouse. That still happens today, but it's of varying utility depending on what courts are looking at these issues. So we're going to walk through this morning in somewhat chronological order how these issues actually play out in practice. And John, Jeremy, and I have done a lot of these cases from a lot of different perspectives, so each of us are going to take a role as we discuss the issues. John is going to discuss the perspective of the employer, the current employer who has the trade secrets. I will talk about the issues from the point of view of the departing employee, and Jeremy is going to take the position of the competitor, the new employer, and sometimes the startup company that is acquiring the departing employee. So, John.
Thank you, Beth. Good morning, everyone. Beth has been discussing one of the very powerful interests at stake when one of these disputes arises, where an employee who has access to a business's valuable trade secret information switches jobs to join a competitor or to start his or her own competing business. The other powerful competing interest at stake in these disputes is the employer's interest in protecting an advantage that it has acquired over its competitors by investing and innovating in its business. That, of course, is the interest that trade secrets law protects. And so, like other intellectual property protections, trade secret law is intended to promote innovation and invention, to foster research and development by entitling the owner who makes the investment to reap the fruits of that labor and investment. A competitor who isn't investing and isn't innovating shouldn't get to reap the rewards of a business that does, and shouldn't get to free ride on the efforts of others. That, at least, is the policy underlying the trade secrets laws and the other competing interests at stake in these disputes. So, what is the information that is protected by trade secrets law? This is a question that looms very large in these disputes because there is a common tendency among some employers to consider almost everything that the departing employee had access to be a trade secret, or to over-categorize information as a trade secret. Not all information that a business would like to stop its employees from carrying over to a competitor is protected as a trade secret. There are three elements that go into determining what a trade secret is, and those are: one, does the information have independent economic value? In other words, does it allow the employer to make money or to save money? Two, is the information not generally known in the industry to the public or others who can realize economic value from it? In other words, is it a secret? And three, is the information subject to reasonable efforts by the employer to maintain its secrecy? So, in short, does it allow the employer to make or save money? Is it actually a secret? And does the employer treat it like a secret by guarding it from others? So let's be more concrete about the types of information that can be a trade secret. As I said, this is often hotly contested by the migrating employee in these cases, and employers often try to stretch the limits. But there are some established categories of information that classically can fit into the definition of a trade secret, and those are shown here. Know-how, such as techniques, processes, formulas, or specifications. Internal leads for new business, for clients, for projects that the employer invests time and effort to develop. Negative knowledge, meaning investments in techniques and processes and formulas that the employer has determined are unsuccessful and should not be pursued, is information that they would want to guard from a competitor. The information need not be in writing, and it can also include confidential information about your employees, such as what their specific unique talents and abilities and compensation packages are. I want to point out that the fact that certain type of information fits in one of these categories isn't enough to make it automatically a trade secret. It still has to meet the other parts of the test we just discussed, which are: is it actually a secret? Is it treated like a secret? And does it have economic value?
Thanks, John. This is Jeremy. Good morning, everyone. So, having John just described what is a trade secret, the question is what isn't a trade secret. And as John explained, the California's Uniform Trade Secret Act defines what is a trade secret. Anything that fails to meet the elements set forth in the act is not a trade secret. And of course, that sounds obvious and probably not terribly helpful, but the primary point here is that the default position is that information is not a trade secret, and the plaintiff bears the burden of establishing the elements to qualify that information as a trade secret. The types of information that are often claimed as a trade secret in these sorts of cases, but which often are not, roughly fall into two categories. The first is general knowledge and skills acquired on the job. The best example of this is on-the-job training. It's very understandable that employers want to claim as theirs the investment that they make in their employees in giving them on-the-job training. But the fact is, where that is not a secret process that they have taught or trained their employees, it's not trade secret information. And a good example for those, for example, who are lawyers on the call is many of you may have at one point in your career hired new lawyers into your office. You may have taught them much about how to actually practice law, but much of that information, of course, is not a secret. And the fact that you've invested that training in them doesn't mean that you can claim that on-the-job training as a trade secret. The second type of sort of general category information that really isn't a trade secret is readily available information that the employer has not in some way transformed. So this is publicly available lists or data which have not been culled or refined or combined or in some other manner meaningfully transformed such that they would become a trade secret. So, for example, customer lists are a good example. The cases are legion about whether customer lists are or are not trade secret. And basically what these cases come down to is how much effort was put into taking what had been probably a very publicly available long list of potential customers and turning that into a much more refined list of more likely customers in that particular market. Another example in the high-tech field is where a company develops some process which is really just a unique combination of publicly known prior art. The individual components of that process may very well have been publicly known. They may have been in the prior art, and unless they're put together in some unique way, combined in some unique way, that's not going to be considered a trade secret. So having defined what a trade secret is, the question in a case involving trade secret misappropriation is, what is misappropriation? Just like the definition of trade secret, the definition of misappropriation is defined in California's Uniform Trade Secret Act. The key upshot is that misappropriation is really quite broad. The term, in at least its common usage, may suggest merely the act of taking. And yes, certainly acquisition of trade secret information by improper means would constitute misappropriation. But it also extends as far as the unauthorized use or the unauthorized disclosure of trade secret information, even when the party did not themselves unlawfully acquire the information. So two good examples of, just to illustrate the breadth. One, the statute incorporates something of a negligence standard in that a party can be held liable for misappropriation when they merely had reason to know that the trade secret information was acquired through improper means. And second, misappropriation extends even to situations where the defendant uses or discloses information that they obtain through no wrongful conduct of their own. In fact, no wrongful conduct perhaps at all, but rather simply obtained through accident or mistake. And it's really worth pausing for a moment and considering that point, which is that merely obtaining information through accident or mistake, where one has reason to know that information was obtained by accident or mistake, and that they have reason to know that it's trade secret information, can give rise to a claim of misappropriation if one then goes ahead and uses or discloses that information. Next are classic examples of misappropriation. The first, particularly in these sorts of cases, are the use of customer lists by the departing employee when they go to their new employer to solicit the former employer's customers. As I mentioned, these cases really are legion, and it's something that you always want to look for when you're involved in these cases. I should note further that it can also extend not just to customers, but also other third parties, for example, vendors or suppliers, can also be the subject of trade secret information. So there may be particular vendors that in a particular field are, or for one reason or another, subject to this sort of protection. Another very common example in these in these cases are the use of confidential employee information to entice, or that is to solicit, employees at the former company to join the new company where the employee has left. And that sort of confidential employee information most typically is information regarding compensation, information regarding their skills, and also their abilities, and how well they performed at their prior firm, all of which can be used by the new company, the competitor, to very carefully target those employees that would be most important, both to helping the new competitor and also causing damage to the former employer. Another example that we've seen in some recent cases, which again goes to the extent of misappropriation, is that even posting algorithms, for example, that were obtained through reverse engineering, which typically is permitted under the trade secret statute, but if they were reverse engineered in violation of a licensing agreement, can also constitute misappropriation. Moving on to some newer applications that we have been seeing in this area, one of the big new areas in which we've been seeing misappropriation is in the quote-unquote market sensing field and related corporate espionage. This occurs often where an employer has certain third parties with whom they do business, whether it's obviously customers, consultants, vendors, or suppliers, and through those third parties obtain information about their competitors. That information was often provided to those competitors pursuant to an NDA, and therefore it was provided to the customer in a manner in which it was not supposed to be shared with others. And if you therefore try to make use of that information, you could be engaged in misappropriation. Another variant of that is where a third party, again a customer, a vendor, or supplier, is provided access to a competitor's systems, whether through a login or otherwise, and then that third party provides that access to you. There again, even though you've done sort of no misappropriating, you would think anyway yourself, merely taking advantage of those sorts of that information or that access can constitute misappropriation. And it arises a lot in cases where there has been employee migration, because those employees, of course, had access to that information. They had access to that login information, and they had access to it at their old company for lawful purposes. They take it with them when they go to the new company, and that can lead to claims of misappropriation. Moving on to what isn't misappropriation, one of the big examples here in California, and largely unique anyway in California, is the doctrine of inevitable disclosure. This is a doctrine which is recognized in many jurisdictions, but not in California, which provides that when a employee from one company moves to a new company and they take a very similar position in that new company, and a position which almost inevitably would result in that employee using information, specifically trade secret information that they acquired from their prior employer, that those employees can, in some jurisdictions, be enjoined actually from taking that position. As Beth mentioned earlier, California has a very strong policy in favor of permitting employee mobility, and therefore this doctrine of inevitable disclosure has not been recognized in California. It's been viewed really as sort of an ex post covenant not to compete, for which the employee did not even bargain, and which in any event could not be enforced in California. And so the doctrine, as I say, has not been recognized. That is to be distinguished from threatened misappropriation, which can be enjoined in California. And the distinction really is that a case of threatened misappropriation involves an actual situation where there's actual evidence that there is likely to be misappropriation. And in those cases, the threatened misappropriation may itself be enjoined. Another very big category in which does not constitute misappropriation is where, of course, the trade secret information was independently derived by the new company. It's perfectly permissible for a company to try on its own, without making use of any stolen materials, to independently derive whatever process or other trade secret information that another company may have. And it can even actually try to do that through reverse engineering of a competitor's products. And so, for example, if you're a manufacturer of a product that goes into the general commercial stream, anything that may be learned from reverse engineering that product is typically not going to be subject to trade secret information unless there are some protections placed upon it through, for example, a license or some other agreement. So now we're going to talk a little bit further about some of the policies that are in tension, and I'm going to turn it over first to John.
Right. So we've introduced now the two strong competing interests at stake when an employee who has access to valuable confidential information switches to a competitor. And so what we want to get into now is exactly how these disputes arise and what happens when these two policies collide. Courts have acknowledged this tension which exists between these vigorously competing interests. And as this slide shows, for example, in the More Life case, the court acknowledged that while an employee's interest in selecting the occupation of their choosing is among the greatest freedoms and commercial rights that we have, it's also fundamental to the preservation of our economic system that we reward the industry that one invests in the success of the business. So in these disputes, this tension becomes a prominent theme that plays out very explicitly and in a very real way to the judge and the jury. It's a tension that exists in other areas of intellectual property law as well, of course, between free competition and ownership of ideas. So let's talk about the paradigm for how these disputes arise. It's a very common fact pattern. Some of you undoubtedly have experienced it already. An employee has access to critical know-how or relationships. The employee sometimes has soured in his or her relationship with the employer, sometimes has developed some negative attitudes toward the employer, and sees an opportunity to jump ship and go to work with a competitor or launch a competing venture. This employee can produce with the new employer faster or get results faster with a new competing venture if the employee uses the head start that he or she has from the confidential information that he or she had access to with the former employer. This puts each of the players in our story in a quandary. And so let's look at the quandary that each of them faces. The employer has invested a lot of money in valuable intellectual property. The employee maybe had access to the business's single most important idea and information, and it's faced with potentially catastrophic business losses. So how is this a quandary? The difficulty is time is critical at this stage. The employer has learned that the employee is leaving and doesn't know all the facts yet. There may be scattered pieces of information. There may be some suspicious circumstances, but these cases, if they end up in court, turn on the details, and details that are often not known at this early stage. Those details include things like, what has the employee already been doing and saying in planning to make the move to the competitor? Who has the employee been talking to? What information has the employee used, taken, sent, saved, copied down to a thumb drive? And what are the employee's immediate plans after leaving the employer? These are critical facts, and delaying, if the employer delays, it could damage the business irreparably by allowing the valuable information to leave. On the other hand, jumping the gun and suing immediately could drag the employer into a lengthy and costly dispute funded by the competitor, and there might, in the end, be no there in the sense that the employee hasn't actually taken confidential information. So the employer has a very difficult decision to make at this point when not all the information is known. Some employers, in my experience, at this time, sue to resolve the doubts that they have, hoping that they can learn the facts, that they'll get information to resolve their questions, or that they'll get a quick settlement, which often happens, that will limit the employee's activities or even the new employer's activities after the employee leaves.
So now I'm going to look at this from the perspective of the employee that is looking to move to a new job, potentially start its own competitive business. From that perspective, the departing employee obviously starts having shifting loyalties away from his or her old employer and onto their new venture. And at the same time, they often have a very vague understanding of what their old obligations are. They may have signed a confidentiality agreement at the beginning of their employment. They may have been handed an employee handbook, which describes what information their employer considered to be confidential. But often in the course of one's job, particularly if it goes on for years, that gets very fuzzy, and many employees begin to think of that information as theirs, stuff that they developed, they learned, relationships they acquired. At the same time, they're anxious when they move or decide to move to make a good first impression and hit the ground running. And they believe, rightfully or wrongfully, that most of the information and skills they've acquired over the course of their career that they can take. You know, for example, if they've worked with various customers or clients over a period of time, they may view all the information about those customers or clients theirs. If they've worked in a particular field and done a lot of research and development, they may consider that they're entitled to take that information with them. In addition, they also may think that they can recruit their friends and colleagues to the new firm and use information they have about what their compensation packages were or what their particular skill sets or the knowledge that those co-employees have worked on to help recruit them to the new venture. And all of this is usually done in great haste and without much thought to the consequences. So one of the things here is one of the lessons that we've seen and learned is there is often a well-marked trail of forensically recoverable evidence that the former employee leaves behind, particularly on laptops or computer systems that are turned over to the old employer when they leave, or their email.
The context in which the upstart competitor may find itself is where there has been at that competitor no established business, product, customer, or employees in that particular space, or just generally for the competitor, for the upstart competitor. And the whole reason that the upstart competitor has recruited this particular employee that's migrating is in order to often start that business, to establish that business, or perhaps just to jumpstart the business and to jumpstart the relationship with customers. Often the migrating employee is one who has been in the business for some time, who has a established reputation, established relationships with customers, and that's one of the primary reasons why they're so valuable to the upstart competitor. So they're a key hire to the business. What's more is that the first 90 days can be quite critical in that situation, particularly if it's a truly startup company. There may be financing issues such that they need to perhaps meet certain goals in order to get access to additional financing, or simply to make use of the financing that they already have. The migrating employee doesn't want their contacts with customers to grow stale, and of course no more so does the competitor who has hired that migrating employee. And so they want the employee to get to work right away, and they want them to get to work firming up those customer relationships. There may also be an interest in bringing with that migrating employee their group, whomever they worked with at the prior company, and therefore there may be an incentive to try to hire additional people either with the migrating employee or shortly after the migrating employee joins the upstart competitor. That can lead to risks of claims of employee raiding, which more basically include the use of trade secret information in order to raid employees at another company, or doing so in violation of their employment agreements. And while all of that is going on, the upstart competitor needs to keep in mind that whatever the employee is doing in order to firm up those relationships with its customers, in order to meet targets so as to perhaps secure financing or other goals that have been set for that migrating employee, whatever that employee is doing may be imputed to the employer, their new employer. That is the company that needs to be concerned about managing its risk, now having hired often a critical employee, not only to its own business, but to its former employer, who, of course, as John described, is often rather unhappy about that migrating employee having left and possibly taking information with him or her. So, as all of that is unplaying, it's important to also note that the competitor, the upstart competitor, typically has no intention to steal any trade secrets, typically just wants a smooth transition. And they are hiring this person specifically because they have certain expertise. And so while they don't want that person to use trade secret information, One of the primary reasons that they probably did hire that person is because of their experience, because of their relationships in the space, because of the value that they can bring to the company in a short period of time, value that could not be brought by perhaps, certainly most others, and sometimes any other people. It's also important to bear in mind that at-will employees are fair game. It's perfectly permitted. In fact, it is something that the courts try to favor to compete for employees in the labor markets. That's why there, for example, is no covenant to compete, non-compete covenants that are permitted in California, at least in most cases. And so the upstart competitor is just looking to hire these employees that are fair game. And what's more is that they're typically doing so in a context in which they really don't know what the former employer's policies were about trade secret information. They may have some vague notion, of course, that they would prefer to protect trade secret information, but they don't really know what that information is. They don't necessarily know what the employment contracts stated, or whether there were employment contracts between the migrating employee and his or her former employer, and therefore they're working also in something of a vacuum of information about what might be permitted in the circumstance, and doing so in pretty quick fashion. So now what we want to, having set up some of the incentives and problems that face the various parties in this situation, we want to move on to some practical advice for avoiding and minimizing disputes. And John is going to start in his role as the employer, discussing some advice to the employer.
So what are the very practical steps that the employer should take to try to avoid these disputes, and if a dispute arises, to minimize it or hopefully resolve the dispute? For the employer, the critical advice starts well before a problem ever arises, and the most important steps that the employer can take is to implement a trade secret protection program before anyone is suspected of leaving for a competitor. Without a program like this in place, a trade secret claim often is going to go nowhere and may just result in a judicial finding that the employer's information is not the employer's and can't be protected, in other words, as a trade secret. Anyone can take and use it, because recall that a critical element of the definition of a trade secret is that the employer treats it as a secret by implementing reasonable steps to protect it from others. So having written policies in place is a critical step long before one of these conflicts arises. And this lays out what many of those policies are. It's critical to establish the trade secret protections by, number one, limiting the dissemination of the information. If the employer wants to establish that the information is a trade secret, then it should take steps to limit dissemination to people, including employees, who have a need to know the information. And it can also use technology to protect the trade secrets, like password protected servers, separate systems, in order to ensure that only people who have a need to know the information gain access to it. It should also enact written confidential policies, not only with employees, but also with visitors to the premises, with third parties with whom the employer deals, who may have a need to gain access to the information through written confidentiality agreements. When there is a violation of one of those agreements, the employer should take it seriously and take steps to enforce the written confidentiality agreements to show that it actually has taken steps to protect the information. It should, however, try very hard to tailor the confidentiality policies, and in particular, their definition of the information that is protected by them to the business in particular. There is a problem that often arises where the confidentiality agreements are written so broadly that they would essentially encompass every piece of information that an employee comes into contact with during his or her employment. In those circumstances, the employee has a very good argument that there was no way to know what information truly is confidential, truly is a trade secret, because the agreement is written in such overly broad terms. So rather than saying it's everything, it's best to take into account what really is the competitively sensitive information that gives an employer an advantage over its competitors, and to tailor confidentiality agreements in that way. The employment agreements themselves should define what the trade secrets are. Another way to avoid these problems is to have some forms of deferred incentive compensation so that the employee isn't entitled to receive that compensation until at least some brief period after the end of the employment. While some forms of employee compensation can't be deferred and have to be paid immediately, equity buybacks, for example, can be used to ensure that the employee remains loyal for some period of time after the end of employment. And non-solicitation provisions should be included in employment agreements, but again, they should be limited to what's lawful. Non-solicitation provisions are lawful during the term of employment when the employee has a duty of loyalty to the employer. After the conclusion of employment, non-solicitation provisions generally are only enforceable in California to the extent they're necessary to protect the trade secrets of the employer. It's important, again, to craft these agreements narrowly and to tailor them as narrowly as one can, because in many instances, courts are unwilling to sever provisions that they find unenforceable and overly broad and to rewrite the agreement to make it enforceable. So sometimes overreaching by the employer will result in the entire agreement being thrown out. There should be an audit done when the employee leaves to require the return of property and files, and that should be part of the employee agreements. The employee agreement should also provide that the employer can monitor computer usage and also select the applicable law so that the rules that will apply will be clear. And it may be that if the employer is in California and is aware that these covenants won't be enforced and exactly what the parameters of an enforceable agreement are, that California law is the right to choose in this circumstance. Now, those are the steps to take before a defector is known or suspected, but when one is known, you still, of course, can't stop employees from quitting and finding work with competitors. That's inevitable. So what steps should be taken once the employer suspects that an employee might be breaking the rules and running off with valuable information? First, other employees often will be important sources of information. They may have had discussions with the suspected employee. They may have observed suspicious conduct. They may have been approached by the suspected employee. And so talking with them is an important first step. The computer investigation in these disputes is critical. Over and over again, we've seen that the employee cannot resist taking the preliminary steps to form the new business, to discuss the new business's projects, to discuss which customers or clients the new business will be servicing, what types of services it will be offering or products, what sort of technology it might have access to on the employee's employer-issued computer. Employees often think that if they use webmail like Gmail or Hotmail, that the employer can't see that. That very often is not the case. Emails like that are often forensically recoverable, even if deleted from the computer or from the account. Sending emails to themselves from their employer email accounts to other email accounts, copying things to thumb drives or to external hard drives are all steps that are often forensically detectable and can give the employer critical leverage at an early time if detected soon and used correctly with the departing employee and the new employer. One very practical thing to keep in mind is if you're going to do a computer investigation, don't do it yourself. Don't even turn on the computer. Turning on the computer itself alters data. It alters data so that it's not in exactly the same form it was in when the employee last used it. Set it aside and use a forensic expert.
And sorry to interrupt, but just to add to that point, one of the critical ways in which even just turning on the computer can cause problems is that it can alter last access dates for various documents, because those last access dates actually are very fickle. They can change even when virus programs run, for example. And those last access dates, although sometimes fickle, can also be very telling about what an employee was doing just prior to their departure. So you really want to maintain the information in as intact a fashion as possible.
That's right. Turning the computer on also can make it harder to recover some deleted information, because deleted information, as we all know now, resides on the hard drive still, but as the computer is used, it is written over. And so leaving it in the last condition in which the employee had it is going to maximize the ability to recover deleted information. With regard to the departing employee, document what the employee says in an exit interview. Consideration should be given at this time to terminating the employee if information is found that indicates that the employee may be planning to use information to harm the employer, and in that instance, getting a severance agreement, ensuring that all property and files are returned, and getting the employee to acknowledge his or her continuing obligations to the employer in a written agreement is an important step at this point. Among other things, reminding them of their obligations is important, because they won't be able to contend later that they were unaware that the information that they were using was a trade secret, that they had an obligation not to continue using that information. And as we'll get to later, the remedies under the Trade Secrets Act for willful misappropriation have considerably more teeth than inadvertent misappropriation or negligent misappropriation. So it's important to set up the possibility of those added remedies by reminding the employee at this time to observe the continuing duties. Finally, consideration should be given to whether it's necessary to communicate with customers or clients and with other employees to discuss with them a key employee leaving, to discuss the continuing relationship with them. Obviously a very sensitive topic that's going to vary depending on the particular circumstances of the case. Next, put the new employer on notice of your concerns. Writing a cease and desist letter is very often the critical step at this point, so that the new employer is aware of what the departing employee's obligations are. And again, this may be the step that gives the employer access to added remedies against the new employer, in the event that the dispute ends up in court. The one thing to bear in mind here, again, is not overreaching, because if in this letter the employer overreaches and tries to assert an unenforceable non-compete, tries to assert trade secret protection over information that isn't, and the new employer backs out of the relationship, then the employee may have a good claim against the former employer for interfering with the employee's new relationship.
So now we're going to switch to the employee's perspective and what you do if you're advising the employee. There are different issues and there are different obligations of the employee depending on the timing. Certain obligations and duties arise while they're still employed by the old employer, and those shift to another set of obligations after they leave the employment and join the new employer or start their new enterprise. And it's very common for employees not to seek legal advice during this transition. As I mentioned earlier, they have their own sense of what they can and cannot do, what they can and cannot take, but it's often inaccurate, and it shades more favorably to them and their own goals and aspirations and desires than those of their former employer. So while they're still employed, the loyalty to their former employer is the touchstone, because there are two claims that could be asserted against them for what they do while they're still employed. One is the breach of the duty of loyalty, and the other is a breach of fiduciary duty. There also may be some breach of contract claims. So first, it's very important that the employee return the employer's property and information, and that they make sure that they do it in all their different realms, that they check not just where their work, but if they have any employment materials at their home. Over the years, I've seen examples of people who've got boxes in their garages, or for old laptops that are just residing at home, and that they make sure they check any and all of their computers and their handheld devices. This is particularly common these days because people are so mobile and people work in all different places because of the ease of technology. They are, of course, entitled to take their personal information. They just need to make sure that they retrieve it safely and that they segregate personal from work information. The employee should also take stock of any of the employer policies and contractual obligations. They should look to see if they what contracts they signed in the past. Was there an employment contract? Were they given an employee handbook? Did they sign some form of confidentiality or non-disclosure agreement? And read it and make sure they understand what applies to them. They're also entitled to take a look at their employment file and see if there's anything in there that they need to be mindful of. As we earlier mentioned, they need to be very mindful of the data trail that they are creating. The emails that they're sending, particularly to their home addresses. I just heard about an issue last week where an employee was emailing herself huge numbers of emails that the employer found out about, and then was able to have a roadmap for what that employee was doing and where they were going. As John said, as much as the employer wants to document compliance, that's helpful to the employee as well, because it creates a defense in the event of a future claim. It's also very important for the employee to be careful about what they're doing either during or after working hours. For most professionals, it's presumed that all of your hours are to go with your employer. So you need to be very careful about what steps you're taking and how you're doing it. Again, communicating with customers, coworkers, prospective employers, folks that you may be seeking to get financial investment. You need to be very careful about what you're saying and doing while you're still employed, particularly if you have some sort of non-solicitation obligation during that time. Once you leave, the obligations shift. It's no longer duty of loyalty because you no longer have that to your former employer, but you do still have an ongoing obligation not to use or disclose any confidential information that you received while you were employed. And this is the tension that we've been talking about throughout this program, which is you are entitled to compete fairly, you are entitled to move jobs, you are entitled to work for a competitor, but what you can't do is use protected confidential information of your old employer. You are also entitled to communicate with your former coworkers and customers. You just have to be very careful about the type of information you do when you use those communications. So things to be incredibly to be aware of are, tools that you actually created, customers that you originated, information that you have in writing versus information that's in your head. All of these create the circumstances about which these claims arise, and it's just important that you document carefully as the employee what you're doing to ensure that you're not overstepping the bounds.
So turning to advice for the competitor or the upstart who has hired this migrating employee, one important thing to do at the outset is to make sure that if you are providing advice to such a competitor, that they understand that they do face risk. They need to acknowledge and understand that there's risk of liability, even if they, the competitor, did not itself engage in trade secret misappropriation. They may be liable for having induced the migrating employee to breach his or her duty of loyalty. They may be liable for inducing tortious interference with contract. They may be liable for participating in the acquisition of the trade secrets with knowledge that the employee had a duty of confidentiality or using those trade secrets. So there are various ways in which the competitor, and not just the entity, but also the individuals, the officers that had the knowledge and participated in having the employee migrate, may be liable themselves individually. So there is risk to the competitor. One thing, after everyone understands that there is some risk, you should take stock of the employer's policies about the use of information that was obtained by employees while they were working for former employees, and what contractual rights the employer has concerning that sort of use of information. Clearly, you want the policies to be very clear that employees who come from elsewhere cannot use trade secret information or other confidential information that they acquired while they were at other companies, and you want to maintain rights to remedy any violation of those policies, including if you think it makes sense, given the business context and the litigation risk, to terminate their employment. You want to document the requirement that employees comply with these policies. And this is not just a matter of papering your record. As I said, competitors really do face liability. You face exposure, as do some of the individuals who may have participated. And so you want to be serious about having migrating employees comply with these policies. And things to consider are making sure that the discussion about this issue is not a discussion that the migrating employee have with a relatively low-level HR officer in the context of a 2, 3, 4-day training session where they're provided all sorts of information, very little of which they actually remember. The message you want to communicate is that you're very serious about complying with these sorts of policies. You should consider that being a conversation that maybe the employee has with the law department or in-house counsel. And you want to also establish a way for that migrating employee to be able to communicate with people who are in a position of authority, whether that be in the law department or elsewhere, if they are feeling coercion by their business superiors to use information that they acquired in with their former employer, and that's actually not uncommon, and we see that as well. That and this is particularly in businesses that involve foreign, whether it's divisions or subsidiaries or parents that may not have the same understanding of trade secret law, or just maybe not the same, in some cases, law at all. And there is pressure often from those foreign groups, subsidiaries, divisions, etc., what have you, to use the information that those migrating employees acquired. And it's important that those migrating employees have a way to communicate that they're facing that sort of pressure to the law department, so that the law department or other senior officials at the company can take action before a problem really arises. You want to make sure that the company is documenting any independent discovery of trade secret information. This is, as I mentioned, one of the main defenses to trade secret misappropriation claims, is that the information was actually independently derived by the new company, the upstart. And so you want to make sure that that's documented. In the technology world, particularly with more mechanical engineering and other sort of basic science, it's often the case, in fact, it's standard practice, that engineers and scientists in their lab books will very clearly date every page on which they've done work, so that you can easily go back and see the development of some new process and when exactly that occurred. Whatever the situation may be, you want to make sure that there's some process, whether it's manual dating, whether it's computer monitoring, whether it's creation of status memos at important points along the way in the development of information, that all of that is documented so that it's clear that that came from sources other than the migrating employee, and particularly information that the migrating employee may have learned at their former employer. You should take caution in any written communications between the competitor and the employees or customers of the former employer. Obviously, anything you put down in writing could be used at some point in litigation, and there are lots of ways in which you can say things that you shouldn't. And so you really should be very cautious about any communications with former employees or customers of the, employees or customers of the former employer. As always, where there's a potential conflict that may arise between the migrating employee and the new company, you might consider engaging separate legal counsel. That's obviously a sensitive issue, but it may be one that's necessary, particularly where it looks like maybe that employee actually did engage in some misconduct, and you want to set up a situation where you can insulate the company from further liability. You may want to consider a waiting period where you have the new employee basically cool their heels in a department that's really unrelated to the work that they previously were engaged, so that it does not appear as though they really would have any opportunity or reason to use trade secret information from their prior employer. That, of course, can run counter to your interests, your business interests, particularly where you're maybe a new company or getting into a new space and you really want to hit the ground running. But depending upon the legal risk that you may face, that may make sense. Similarly, as I just mentioned, you want structural initial assignments to minimize the threat of misappropriation. If you receive letters from the former employer that are threatening, that suggest that there has been some sort of misappropriation, you need to consider obviously how you want to respond. And one way is to be very aggressive and quick in response, so as to send a very clear message that you're not cowed by those sorts of threatening letters. But on the other hand, you may want to take the opportunity to be very thorough, deliberate, and considered in responding, and make sure that you really know the facts that that happened prior to responding, so you make sure that you don't say anything that you may later regret. And similarly, you may want to consider initiating dialogue with the former employer if you think that maybe there was a problem and maybe you can resolve that problem in an amicable fashion before litigation arises. And with that, we'll move on to some common pitfalls, first by the former employer, and so John will take that up.
So where does the former employer make a costly misstep when these disputes arise? I categorize them into two groups, the first being underreaching or underreacting, and the second being overreaching. In the first set of mistakes, the employer doesn't act quickly enough. And if injunctive relief is going to be sought, and sometimes it is the most critical form of relief in one of these disputes, it needs to be sought quickly, as soon as the employer has enough information to seek it. Also, sometimes maximum leverage for the former employer really exists at the earliest possible time before the employee has gotten too entrenched in the new employer. I've seen in several instances where the employer has strong suspicions and some concrete information that there is misappropriation happening, but is reluctant and waits, and the leverage slips away and the moral high ground slips away for injunctive relief. Also, some of these cases just get worse from the former employer's perspective the farther they go along. So acting quickly can be critical. In the same category of underreacting, not taking steps to manage other employees. Sometimes the first suspected employee really is just the tip of the iceberg. It's critical to get in there and figure how widespread the issue is so that the employer can stop the bleeding. Secondly, the second two categories I put in the overreaching category, and that is, even today, some employers will still seek to enforce non-compete provisions not enforceable in California, or overly broad non-solicitation agreements, or contracts that define the scope of trade secrets way beyond their legally justified limits. Doing that, again, creates the impression that the employer is just trying to stifle or crush a new competitor, and puts the moral high ground on the side of the departing employee and the new employer. So taking a more scalpel-like approach and tailoring it to the particular circumstances is generally going to get a better result than overreaching.
The employee pitfalls are really the flip side of what I spoke about earlier, about things that the employee needed to be mindful of when they were thinking about leaving or competing with their former employer. And as John had put his into two categories, I think of these into three separate categories. The first is, what kind of information can you take or use? The second is, what kind of activity can you do while you're still employed? And the third is really your own attitude, your sort of good faith belief that everything is going to work out. So on the information that you can take or use, the common mistakes that we see are just forgetting to return employers' property or information, or being sloppy about not checking in your home or your garage or your car. We've seen that many times over the years. Another is recycling templates or forms, strategic plans, PowerPoints that you developed at your former employer. Obviously, in this day and age where we're all asked to do more work in less time, it seems so much simpler just to take something you've done before and recreate it. But the old form may contain confidential information that you should not be using. Similarly, if you've just done a data dump of your emails, your contact lists, when you were leaving, you may have inevitably or inadvertently combined a lot of personal information with information that really belongs to the company and you shouldn't have taken. And then, as we've mentioned repeatedly, you're creating a trail that makes it much easier for your former employer to go after you. In terms of the categories of activity while you're still employed, the most important thing or the most common mistake is really starting to do work for the new employer or starting to develop a new business while you're still employed. So you begin to actively compete and your loyalties are really in tension. You may inadvertently use your old employer's resources, or you may be improperly communicating with a whole host of vendors, customers, prospective investors, and you really should not be doing that as an employee while you're still employed. And then the third common pitfall is really what I would categorize as sort of a good faith belief, thinking that you can do things that you shouldn't, overlooking contracts that you've made, agreements you've signed, and thinking that your old employer for whom you worked for a long time and may have had good relationships with will overlook any indiscretions.
As for the competitor, really the primary pitfall is not managing the risk and the situation and taking a somewhat laissez-faire approach, simply allowing the migrating employee to do what they will. And pretty much all of the examples here, or at least most of the examples listed on this slide, go towards the point of making sure that you're managing the risk, that you're not leaving it to the employee to comply with their duties, and that you understand that what those duties are, and that you make sure that the employee is complying with those duties. So then we're going to move on to the question of what happens if litigation arises. And here again, we'll start with John, who will speak to the considerations for the former employer.
Beyond the obvious considerations that arise in many litigations, such as business disruption, which in these disputes often is very significant because the dispute often affects other employees in a personal way because the dispute is with one of their former friends and colleagues, and or they may be personally involved in what's happening. One of the very significant considerations that an employer needs to take into account if it's considering going into litigation on one of these is that it could lose in a very public way and give a green light to others to use the confidential information that it is contending is a trade secret. So there is a high risk in these cases. Also, customer perception is a big issue, and employers who bring these claims don't always fully recognize the impact on their business of customers who may be related to the departing employee. Maybe the allegation is that the departing employee has taken their business. Inevitably, at some point in the case, it will be necessary to involve those customers in the dispute, and that's typically not the best form of customer relations. Of course, if they've been lost already, that consideration may not carry a whole lot of weight.
From the employee side, obviously the employee is very concerned about their income being disrupted, the time that they may have to spend in litigation, certainly the hit on their reputation if they're accused of misappropriating their former employer's trade secrets. Also, employees obviously want to be used in the most profitable way possible, particularly if it's a narrow job field, and usually the employees that are involved in these cases are high-level executives or very high level or skilled technical employees. For these reasons, it often is helpful to the employee if there's litigation to either get a quick resolution or an early determination so that their time and their reputation is not impacted and that they're not exposed to large damages. They also want to be able to be cementing their own customer and coworker relationships during this time, and there's a huge stigma attached to this type of litigation. So as with the employer, there's often a tactical consideration for early resolution.
For the competitor or the upstart, in engaging in the litigation, one thing that you'll want to do is to affirm your loyalty to your own employees. So even where the migrating employee may have, in fact, engaged in some misconduct, one question you'll want to consider is what message are you sending to your own employees in how you handle the litigation. And of course, there are the other business considerations that we've already considered about how the migrating employee may be critical to your business needs for various reasons. And there are also other tactical considerations for why a competitor, for example, may want an early judicial determination. They may want to have the matter resolved before damages mount. They may want to have the litigation resolved soon so that they can go on with their business and that they can cement the relationships, hopefully, with their new customers. And but at the same time, they may have concern about how that ruling, how that early judicial determination, or how a settlement even may have continuing precedential value in their future dealings.
As we've noted, these disputes, when they head into litigation, are typically characterized by their fast-paced emergency nature. They often flare up and in many instances resolve within days or weeks of very intensive, fast-paced litigation. These cases are historically classic race to the courthouse cases in many instances, where each of the players involved is seeking a more favorable forum where it perceives the laws to be more on its side. But as we mentioned earlier today, decisions in California have made the race to the courthouse in many instances less important than it was before, because if the employee is going to be working in California, then even if the former employer races and gets an injunction in another state, it's often not going to be worth a whole lot to the former employer, since it won't be enforced in California against the employee. I won't go through each of the legal claims that an employer often is able to make. They're set forth here. The one important point of advice is that the law in California is that the California Trade Secrets Act preempts other state laws, including common law claims that are based on the same set of alleged facts as the trade secrets claim. So careful consideration needs to be given to which legal claims are asserted. As we all know, lawyers often plead every theory they think is potentially viable, but that can be dangerous here, because if the other claims are based on the same set of alleged facts, then they could get thrown out at the pleading stage if a preemption motion is filed. So the advantage, of course, of a trade secret claim is that it's got some sharp teeth in its remedies, which we'll get to in a minute, but it can also be tough to prove. So if the trade secret theory is shaky, it's often best to leave it out and to rely on other theories, because it will just drag down the other claims that might be stronger. Again, I won't go through in detail the civil remedies that are available on a trade secrets claim, but a couple to point out in particular are the attorney's fees provision and the punitive damages provision. The attorney's fees are available to a prevailing party if the claim is brought in bad faith, or where the misappropriation is willful and malicious, setting aside the third opportunity, which has to do with terminating an injunction. The opportunity for the moving employee to get attorney's fees for a claim made in bad faith has some real teeth in California, and if the employer brings a claim which it doesn't establish, the employee can recover its attorney's fees, as well as the new employer's attorney's fees, even if the former employee had enough information to defeat a summary judgment motion on the trade secrets claim. The court can still find that the claim was brought in bad faith, notwithstanding that it survived summary judgment, if the evidence is objectively thin and if it thinks that the former employer had an anti-competitive motive in bringing the claim, as shown by its refusal to engage in good faith settlement negotiations throughout the life of the case. So for purposes of awarding fees here, the court can consider the parties' participation in settlement negotiations. And in my experience, if these cases proceed to a disposition, the winning party will inevitably seek fees and can double the cost of these cases for the losing party.
I want to touch briefly on another aspect of this, which is considering going to law enforcement and pursuing a criminal case, because there are a lot of pros and cons to doing this, which I'll get to in a moment. And we at Arnold & Porter have a number of former AUSAs who have a lot of experience on this from the criminal side. So it's definitely a strategic consideration that should be considered. There's a host of both federal and state laws which you can use which can be used against misappropriation of trade secrets. On the federal side, there's the Federal Economic Espionage Act, there's the Federal Computer Fraud and Abuse Act, a National Stolen Property Act, Mail and Wire Fraud, RICO, Stored Communications Act, Interstate Transportation of Stolen Property Act, and then, of course, the standard conspiracy, aiding and abetting, and criminal attempt. And there are some state corollaries under the California Penal Code. One thing that's also interesting about potential criminal pursuit is it can be pursued not just against the former employee, but the new employer as well. In fact, the U.S. Attorney Manual states that in all cases of wrongdoing by corporate agents, prosecutors should consider actions against both the individual and the corporation. And the law that applies to the new employer is under the doctrine of respondeat superior, a corporation can be held criminally liable for the illegal acts of its directors, officers, employees, and agents. So if it hires a new employee and that employee uses or discloses information that's trade secret of the former employer, or does any of the types of activities that are covered by these various statutes, the new employer is potentially liable if the employee was acting within the scope of his or her duties and the actions were intended, at least in part, to benefit the corporation, which is often the case. So what are the pros and cons of considering civil versus criminal remedy? And I'll do this briefly because we're running a little bit behind. But on the criminal side, one of the great pros is that it's often much more economical to go to a criminal agency, an agency which enforces the criminal laws, because you shift the time and expense of the investigation and the prosecution to the government. It's also very helpful if the trade secret theft is international, because the government has a much larger ability to pursue foreign offenders than you can in civil court. For example, they can conduct border searches and can often get discovery from overseas. The government also has the weapons of search warrants and grand jury subpoenas, which are much broader and a little more scary than the typical discovery that you get in civil litigation. The threat of criminal prosecution and even potentially incarceration is a very strong deterrent to the would-be trade secret thieves. And finally, you typically get federal court jurisdiction for criminal cases under the federal statutes, whereas in California, most misappropriation of trade secret cases are brought in state courts. And there are many benefits, at least in my view, to federal cases over state. Of course, there are a number of cons as well. There's a high intent knowledge requirement for conviction. In other words, it's more difficult to prove and convict in a criminal case than civil. Importantly, as the employer, you lose control of the litigation. Once it's turned over to the prosecution, they get to make all the decisions and they get to control the timing. And that's often very frustrating for companies. There's also greater risk that the trade secrets that you're claiming have been improperly used or disclosed could get publicly disclosed. Again, this is because you lose control of the case once it's turned over, and it's much more difficult to assert protections. And finally, from the employer standpoint, you may potentially get better damages and civil remedies such as a temporary restraining order if you're pursuing a civil case.
The defenses that the new employer has include, as John mentioned earlier, trade secret preemption. That is, that certain claims are preempted by the trade secret claim. And as to the trade secret claim, number one, that the trade secret is in fact not a trade secret for lots of the reasons that we already have discussed, including that it may have been reverse engineered or independently developed, that there was no misappropriation, that there was no damages resulting from the misappropriation. And it's worth emphasizing that for just a moment. Oftentimes people can prove that there was a trade secret, they can prove that there was a misappropriation, and they're rightfully, legitimately upset about that. But in considering whether or not litigation makes sense, you also need to take account of what are the damages. And then, of course, there are the potential for attorney's fees, as John mentioned earlier.
With respect to discovery, from the employer's standpoint, the one procedural wrinkle that I would note is that it is a threshold obligation in a trade secret case under California law to identify with reasonable particularity the trade secrets that are an issue in the case and that the employer is alleging the employee to have misappropriated. At a very early stage, in a case where little is known and the investigation is in its infancy, at some times it can be difficult to do that with reasonable particularity. This often becomes an early fight as the employee and the new employer attempt to stop discovery and to say that the employer either doesn't have trade secrets that it can identify or hasn't sufficiently identified them.
That's right. And in addition to that issue, which really is a major threshold issue, and you can spend a lot of time on it, obviously other efforts of discovery from the employer's perspective will be the proof of the value of the trade secret, whether or not it was actually generally available, and the efforts to keep that trade secret secret, as well as whether there was loss and any evidence of misappropriation.
A few words on settlement. As noted, these cases often generate so much pressure very early when very little is known that the stakes are very high, so that settlements often result in days or weeks in these cases, but not always. Oftentimes, the key terms in these settlements are not money, but about ensuring that the employee doesn't misuse information, and oftentimes that means agreements to restrict the employee's activities after employment or restrictions on the new employer's conduct. In some instances, the old and the new employer negotiate a no-hire agreement that will restrict the new employer's ability to solicit and hire other employees going forward. There are some questions about the enforceability of that kind of agreement under California law. It is pretty clear outside of the litigation context that broad no-hire contracts are illegal restraints of trade under California law, but less law on whether they are lawful in the context of a litigation settlement. Also, that's been an important area of government investigation. A couple of years back, the U.S. Department of Justice investigated and settled with 6 high-tech companies that it had investigated for allegedly entering into no solicitation agreements or anti-raiding or anti-poaching agreements with respect to each other's employees. The settlement restricted them from entering into those types of agreements for 5 years.
And assuming that settlement is not possible, of course, there's always the prospect of trial, but one thing to consider at the outset of the case is actually whether you want to arbitrate the case rather than go to trial. Sometimes there is a contract that has a arbitration provision which you might be able to make use of if you want to be in arbitration, and there may be good reason to do so. It may be that the issues are very complicated, or that there's highly charged evidence, or that you expect there to be, or that there are reputational concerns, all reasons why you may want to be in front of an arbitrator rather than a jury. If you are in front of a jury, particularly in cases where the evidence is likely to be complicated, for example, if you're dealing with high technology trade secrets, you need to give very careful consideration to all of the other types of evidence which are going to be very persuasive to a jury. That includes the computer forensic evidence that John discussed earlier, customer testimony where customers are likely to be viewed as independent, and lies or furtive conduct, which even though may not have actually pertained to trade secret information, will carry great weight with the jury, or instances where there was destruction of evidence or material, or where there is just copy. Again, even if it's not trade secret information, where you have evidence like that, it can seem like there must have been trade secret theft, even if the more complicated evidence may not bear that out.
So thank you, everyone, for listening. We apologize for running over for a few minutes. If you have questions, please feel free to call or email one of us. We will be circulating the PowerPoint this morning, so you will have our contact information. We will also be circulating an evaluation, so please give us feedback about topics you'd like us or our firm to cover in the future. Thank you. Have a great day.
Thank you.
Thanks. A trade secret, and the plaintiff bears the burden of establishing the elements to qualify that information as a trade secret. The types of information that are often claimed as a trade secret in these sorts of cases, but which often are not, roughly fall into two categories. The first is general knowledge and skills acquired on the job. The best example of this is on-the-job training. It's very understandable that employers want to claim as theirs the investment that they make in their employees in giving them on-the-job training. But the fact is, where that is not a secret process that they have taught or trained their employees, it's not trade secret information. And a good example for those, for example, who are lawyers on the call is many of you may have at one point in your career hired new lawyers into your office. You may have taught them much about how to actually practice law, but much of that information, of course, is not a secret. And the fact that you've invested that training in them doesn't mean that you can claim that on-the-job training as a trade secret. The second type of sort of general category information that really isn't a trade secret is readily available information that the employer has not in some way transformed. So this is publicly available lists or data which have not been culled or refined or combined or in some other manner meaningfully transformed such that they would become a trade secret. So, for example, customer lists are a good example. The cases are legion about whether customer lists are or are not trade secret. And basically what these cases come down to is how much effort was put into taking what had been probably a very publicly available long list of potential customers and turning that into a much more refined list of more likely customers in that particular market. Another example in the high-tech field is where a company develops some process which is really just a unique combination of publicly known prior art. The individual components of that process.
Great day, ladies and gentlemen, and welcome to the Tension in California Between Migrating Employees and Protecting Trade Secrets conference call. My name is Katina, and I'll be your coordinator for today. At this time, all participants are in a listen-only mode. If at any time during the call you require assistance, please key star followed by 0, and the coordinator will be happy to assist you. I would now like to turn the presentation over to your host for today's call, Ms. Beth Parker. Please proceed.
Hello, everybody. Our program today is called The Tension in California Between Migrating Employees and Protecting Trade Secrets. I'm Beth Parker, and with me today are John Lombardo from our Los Angeles office and Jeremy Cameras, also from San Francisco. During the program, please feel free to use the chat feature tool within WebEx to ask questions. We will not answer them as we are speaking, but at the end of the program, if there is time, we will try to answer as many of your questions as possible. Since time constraints may not enable us to get through all of them, please do not hesitate to contact any one of us directly after this call, and our contact information will be on the last slide and on the materials that you receive. The lines have been muted. If, however, you need assistance during the conference, press star, then 0 on your telephone, and a conference coordinator will assist you. The event is also being recorded and may be posted on the Arnold and Porter website, where it will be available to the public. Shortly after the program, we will send a link with the presentation materials to all of the participants in today's program for your convenience. So thank you. Theft of confidential company information by former employees has been and continues to be a major problem. This is particularly so in high-tech companies and other companies where a lot of research is happening, whose major assets are the trade secrets they develop. In fact, a major study found last year that nearly 60% of departing employees admitted that they stole company data when they left. 67% of these took it to secure a new job, and 79% knew they should not have taken it. And they took it in a variety of ways. Some took paper files of the competitor, the new employer, and sometimes the startup company that is acquiring the departing employee. So, John.
Thank you, Beth. Good morning, everyone. Beth has been discussing one of the very powerful interests at stake when one of these disputes arises, where an employee who has access to a business's valuable trade secret information switches jobs to join a competitor or to start his or her own competing business. The other powerful competing interest at stake in these disputes is the employer's interest in protecting an advantage that it has acquired over its competitors by investing and innovating in its business. That, of course, is the interest that trade secrets law protects. And so, like other intellectual property protections, trade secret law is intended to promote innovation and invention, to foster research and development by entitling the owner who makes the investment to reap the fruits of that labor and investment. A competitor who isn't investing and isn't innovating shouldn't get to reap the rewards of a business that does, and shouldn't get to free ride on the efforts of others. That, at least, is the policy underlying the trade secrets laws and the other competing interests at stake in these disputes. So, what is the information that is protected by trade secrets law? This is a question that looms very large in these disputes because there is a common tendency among some employers to consider almost everything that the departing employee had access to be a trade secret, or to over-categorize information as a trade secret. Not all information that a business would like to stop its employees from carrying over to a competitor is protected as a trade secret. There are three elements that go into determining what a trade secret is, and those are: one, does the information have independent economic value? In other words, does it allow the employer to make money or to save money? Two, Is the information not generally known in the industry to the public or others who can realize?
Some downloaded information to CDs, DVDs, or USB memory sticks. Some sent it as an attachment to an email and then sent it to their personal home email account. And what they took encompassed a large swath of corporate information: customer lists, business information such as strategic plans, research and development, financial information, and employee records. In California, how to handle this is somewhat tricky due to two competing public policy concerns. On the one hand, California values employee mobility. We in this state want employees to work for whomever they want to, and they can even compete with a former employer. So as a result, except in a few very narrow circumstances, non-compete agreements are generally void in California. By contrast, in most other states, non-competes are generally enforceable as long as they are reasonably tailored. This often means that they must have time or geographic or other boundaries, but you can still have non-competes. But what's interesting about the strength of California's public policy against non-compete agreements is that most California state courts will not enforce another state's injunction against an employee who leaves an out-of-state employer, comes to California, and joins a California employer. And that is true even if the former employment contract includes a choice of law provision that says another state's law will govern. So as a result, there has in the past often been a race to a courthouse. That still happens today, but it's of varying utility depending on what courts are looking at these issues. So we're going to walk through this morning in somewhat chronological order how these issues actually play out in practice. And John, Jeremy, and I have done a lot of these cases from a lot of different perspectives, so each of us are going to take a role as we discuss the issues. John is going to discuss the perspective of the employer, the current employer who has the trade secrets. I will talk about the issues from the point of view of the departing employee, and Jeremy is going to take the position.
Economic value from it. In other words, is it a secret? And 3, is the information subject to reasonable efforts by the employer to maintain its secrecy? So in short, does it allow the employer to make or save money? Is it actually a secret? And does the employer treat it like a secret by guarding it from others? So let's be more concrete about the types of information that can be a trade secret. As I said, this is often hotly contested by the migrating employee in these cases, and employers often try to stretch the limits. But there are some established categories of information that classically can fit into the definition of a trade secret, and those are shown here. Know-how, such as techniques, processes, formulas, or specifications. Internal leads for new business, for clients, for projects that the employer invests time and effort to develop. Negative knowledge, meaning investments in techniques and processes and formulas that the employer has determined are unsuccessful and should not be pursued, is information that they would want to guard from a competitor. The information need not be in writing, and it can also include confidential information about your employees, such as what their specific unique talents and abilities and compensation packages are. I want to point out that the fact that certain type of information fits in one of these categories isn't enough to make it automatically a trade secret. It still has to meet the other parts of the test we just discussed, which are, is it actually a secret? Is it treated like a secret? And does it have economic value?
Thanks, John. This is Jeremy. Good morning, everyone. So having John just describe what is a trade secret, the question is what isn't a trade secret? And as John explained, California's Uniform Trade Secret Act defines what is a trade secret. anything that fails to meet the elements set forth in the Act is not a trade secret. And of course, that sounds obvious and probably not terribly helpful, but the primary point here is that the default position is that information is not